Mr. Chapman, good morning.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Daryl King of cases 10216, case 12, case 15, case 162, 17, 19, and case 19 DP. In each of these matters, Mr. King is here today after failing to appear before this court on July 12th, 2023. In the first case, bond is currently set at $1,454. This is the 9th bench warrant. In the second case, bond is currently $1,704. This is the 8th bench warrant. In the third case, bond is currently $4,766. This is the 5th bench warrant. In the fourth case, bond is currently $9,970. This is the 5th bench warrant. In the fifth case, bond is currently $2,579. This is the 5th bench warrant. Sixth case, bond is currently $4,275. And this is the 3rd bench warrant. And in the final case, bond is currently $1,263. And this is the 2nd bench warrant.
Okay.
He reports no employment. Last payment made on these accounts was in April of 2022. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on November 1st, 2023 at 8:00 a.m. before this court.
Thank you. Mr. King, you're before the court at this time, charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 1st, 2023 at 8:00 a.m. You'll get notice of that in writing. Are you able to post a bond, sir?
Yes, I have a little buddy, but can I say something, sir, if it's possible, Your Honor?
Go ahead.
I sent the lady the disability paperwork. I don't know if you guys got that because I know you guys took half of the settlement. When I got the settlement, when I took the $15,000 and they took my taxes, when I got ran over at work. And I sent the lady the paperwork and she said that she would get back to me. This was maybe 2 weeks, 3 weeks ago, 4 weeks ago, when I found out that I had a warrant, because
Okay.
I'm currently fighting a disability and I'm still going through that situation and I can't really do anything. So she hasn't got back to me or my lawyer. So we're wondering what really happened with that. If you could tell me if you know anything about that, because
I don't know. I won't know anything about that until November 1st.
Yes, sir. I'm sorry, Your Honor.
No, that's fine. Well, you've got a lot of cases and again, a lot of issues in this particular matter. What I'm going to do is, because you have the 7 cases, I'm going to set your bond in each case in the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay. Thank you. You're excused. Have a good day.
So one question, sir. So
Yep.
700 to get out?
Yes.
Okay, thank you.
Okay. You kept going there, Mr. Chapman. I thought we were going to set a record.
So did I. Now before the court is Dawn Patterson. Miss Patterson is here today after failing to appear before this court on April 5th, 2023. Bond is currently set at $11,905. This is the 6th bench warrant. She reports that she is employed at Denso. However, a friend of the court has already contacted that employer and they tell us that she's not employed there. Last payment made on this account was in September of 2022. For the record, that was a $500 bond forfeiture. front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on November 1st, 2023 at 8:00 a.m. before this court.
Thank you. Ms. Patterson, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenant that the next hearing on November 1, 2023 at 8:00 a.m., you will get notice of that in writing. Are you able to post a bond?
Your Honor, I just got out of jail like a week ago. I had to come to court for this right here in December. So how did I miss court, sir? I just got released. So how did I miss court? I had to go to court for this same thing we're doing right now in December. So I did not miss court again for this. They just let me out.
Okay. Well, the last hearing was in April, so it wasn't just recent.
But I got out. I just went to court. I mean, I just got out of jail a week ago. And they
Ma'am.
set a court for this in
Okay,
December. is what I'm
ma'am, that
saying.
doesn't tell me anything. Just
I
getting
didn't
out.
miss court. That's what I'm saying, sir.
Okay, just stop and listen, okay? Try to listen and maybe you'll understand something. You're getting out of jail just recently doesn't tell me anything. It only tells me something if you said I've been incarcerated for the last year, but telling me you just got out a couple weeks ago doesn't tell me. You could have been in jail for 2 weeks. You could have been in jail for a month.
Okay, I understand that, but they set a court date for December for this. And so I have not missed court again for this, is what I'm saying.
Well,
I have a court in December for this,
the date.
and I
that
haven't missed it.
Okay, I guess you just don't like to listen or something.
No, I'm just saying I have court in December for this. So how did I miss court is what I'm trying to understand.
And he said the date that you missed court was on April 5th, 2023, not
Okay.
December coming up, last
No, but I had to
April.
go to court in December, is what I'm saying. He already set another court date for December.
Well,
They set another
we
court
set
date.
another one for you for November 1 is what we set.
Okay, so I was supposed to go to court in December for this too, though. And I didn't miss that court date, so I don't understand why I got to do another one. And I didn't miss it.
That could be a different hearing.
No, it was for child support, back pay child support.
Okay. Ma'am, there are all sorts of hearings about child support. It doesn't mean that that's an enforcement hearing. You could have a hearing on a petition to modify support. You could have a petition for something to
I didn't
terminate
know that.
support. I
I'm
know.
sorry, I didn't know.
The hearing we're going on November 1st is an enforcement hearing. I
Well,
don't
how
know
come
if
they
you-
would just let me out? Why would they let me out then? I don't understand that. And then set a court for this, so I didn't
The
know.
jail made a mistake and you've been made aware of that.
Okay.
Oh, well, I didn't know that. I didn't know. I didn't know. And I just lost my job like a couple days ago. So I didn't know.
Okay.
I'm supposed to be
Well,
going to Hilex when I get out of here.
It is your sixth bench warrant, and you have a sizable arrearage in this particular matter. What I'm going to do is I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't have no $1,000.
Okay, thank you. We'll
Is
see
that
you back.
like 10%? Can I pay 100 to get out?
No, $1,000 cash bond, and we'll see you in November. Thank you. You're excused.
Whatever. Shit.
You want to bring her back in for anything?
No.
I've got a couple of bench warrants for the record. if I-
Okay, Ms. Owen, good morning to you. We're going to proceed with your pro confessor hearing. Do you have the script that we provided you?
Yes, I do.
Okay, what we'll do is we'll have you sworn in, and then you can go through the script, but you do not have to state your address if you don't wish.
I married the defendant on November 16th, 2018 in Battle Creek, Michigan. I filed a complaint for divorce on April 24th, 2023. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all the statements were true. All the statements in my complaint for divorce are still true today. There's been a breakdown of marriage relationships such that objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am currently not pregnant. The defendant and I have one minor child, 4 years old. I have read all the terms of the proposed judgment of divorce, and I agree with them. I ask this court to grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you, ma'am. Court is satisfied. Let me ask you on the judgment there, it's by consent, so your husband would have signed that. Do you recognize his signature?
Yes, I do.
Okay, and it does appear on the judgment?
Yes.
Okay, thank you. Court is satisfied that the testimony does establish the statutory basis. There has been a showing, there's been a breakdown of the marital relationship. The court will enter the judgment in this matter. Court will note that it has been approved by the front of the court. And when I sign that, that will conclude your case. You will be divorced, and best of luck to you, ma'am. I hope everything works for you and you have a wonderful day.
Thank you, Your Honor.
Thank you.
166 days old. Last time we had these people here in September, they said that there were no issues in dispute, so
Right.
we'll see how that happens.
Ms. Keane Kennedy, we were in court back on September 13, 2023. At that time, you had stated that there were no disputes in your case. Is that still correct?
I don't really want to fight through the divorce. I think it would just be best to just try to do it peacefully.
Okay. Mr. Keane Kennedy, are there disputes in the case that you're aware of?
Not that I'm aware of, no.
Okay. Then what we informed you of, Ms. Keane Kennedy, because you are the plaintiff, that you have to prepare the final paperwork in this matter. So you have to prepare a judgment of divorce, a uniform child support order, and a judgment information form. So you'll have to get those completed.
And I did that yesterday, sir.
Okay, well, it's a little bit of a distance from, September 13th. So, I mean, it's better than not having done it, but if you would have done it sooner, we could have potentially have gotten the matter concluded today too.
I tried. My husband said he didn't want to sign anything. So he was back and forth about it, and it just got down to the last minute.
Okay. Well, we have it now. We'll go to the front of the court. We'll see what happens. And then once the front of the court has approved it, then Mr. Keane Kennedy needs to approve it if he's going to. And then we'll be able to have the final hearing. We'll put this back on the schedule for about 30 days so that we can keep track of the case, because I don't want it to languish any longer than it already has. So, okay. Do you have any questions, ma'am?
No, I do not.
Sir, do you have any questions?
Not as of right now.
Okay. Well, we'll see you back in about a month. It could be around, it could be about 45 days, but somewhere in that area. Because it will be again on a Wednesday, and then we'll check and see if we've got the approvals and everything else at that time.
Okay.
So,
2023
you're free to go. Have a good day.
8:50 a.m.
All
You
right.
too.
Good morning to both of you. Court will note that this matter is before the court for a scheduling conference, and the scheduling conference is where we put in place various dates and processes as we proceed so that the case will progress in an orderly fashion. So I'll first ask you, Mr. Wedling, because you are the plaintiff, are there any disputes in your case?
No, I don't think so.
Okay. Ms. Wedling, what are your thoughts?
No.
Okay. Then what's going to happen, if you don't believe there's any disputes, I'm not going to put in place a scheduling order, because the scheduling order would kick into gear the mediation process, whereby an attorney mediator would be appointed to assist the two of you in getting the matter resolved. And there's a cost associated with that. So if you don't believe that you have any disputes, I'm not going to put that in place so that you don't have to incur that cost. But what you're going to have to do, sir, is, because you are the plaintiff, you're going to have to prepare a proposed judgment of divorce and a uniform child support order, as well as a judgment information form. And you would send that to the friend of the court and try to get their approval. If you get their approval, then you can forward it to Ms. Wedling. If she approves it, then all we have to do is wait for the time frame to run, and then we'll be able to complete the case. So I don't know if you have a service that you're working with, like MichiganLegalHelp.org or something of that nature, but go into whatever you're working with, and they'll help you prepare the final paperwork. Do you have any questions, sir?
No, I got the child paper. I gotta take it to there. To the
Yeah, I
courthouse.
filled it out for him.
Okay. Well, we need it. We need a judgment of divorce and the uniform child support order and the judgment information form. So not just one form, you got to have all three of those to submit to the front of the court for approval.
Okay.
So do that. And what we'll do is we'll set this for a status conference in about 45 days. And what we'll do is check back with you at that time to see if how things are going, and then we can see if we can progress. Okay.
Okay.
Do you have any questions, ma'am?
Nope.
Okay. Thank you. We'll let you go today. Have a good day, and we'll see you back in about 45
At
days.
8:54
Thank
a.m.
you.
Plaintiff is attending via telephone.
Okay. Good morning to both of you.
Good morning, sir.
I know, Mr. Brown, I didn't see any beard in the prior picture.
Yeah, no, it's recent. It's recent.
Okay. Ms. Brown, I'm going to go to you first. This is a scheduling conference whereby we attempt to put in place various processes and dates so that the case will proceed in an orderly fashion. But I'll ask you first, because you are the plaintiff, do you believe that there's any disputes in your case?
Good morning, Your Honor. The only, it's not a full dispute. There's only one partial piece that Lamont and I have a difference on, and it's in regards to the property that we shared. We agreed that equity would be paid to me. However, the calculation to determine that amount is different from both of us.
Okay. Well, what happens, I'm going to give you, I don't want to put into place a scheduling order, because I'll tell you what happens. Part of that scheduling order is we would assign the matter to a mediator, and there's a cost associated with that because it's an attorney mediator that would try to get with you to resolve any disputes. I'm going to give you about an additional 30 days to try to work out your disputes, and then we'll have the matter come back for a status conference in that time. If there's still a dispute, then we'll put in place the scheduling order, and the matter will proceed as a contested matter. But if you can resolve it in the next 30 days, then you'll be able to save the expenses of the mediator and all of that. So, Ms. Brown, do you have any questions?
No, I don't have any questions, sir.
Okay. Mr. Brown,
Yes, sir.
do you have any questions?
No, sir.
Okay. Thank you. We'll see you back in about 30 to 45 days. And if you haven't resolved your issues, then we'll set it as a contested matter and it'll proceed in that manner. Okay?
Your
Yes.
Honor, I'm sorry, I do have a question. And I'll refer back to Cheryl as well, because this is a matter that I think we've went back and forth on multiple times. So I'm not sure if anything is going to change within the next 30 to 45 days from our individual standpoints.
Okay. Well, if that's the case, then maybe what we will do is proceed with a scheduling order, and then that will set the matter for mediation if we need to do that.
Right. Unless you disagree, Cheryl.
No, because I still have the same understanding, and you have your understanding of how to calculate the equity.
Okay.
So.
Okay. There is a process for discovery, meaning you can acquire information from the other side through interrogatories, requests for production of documents, depositions, etc. Do you anticipate any discovery, Ms. Brown?
I do not.
Okay. Sir, do you anticipate any discovery?
No, sir.
Okay, we'll put it down for none then. We will set the matter for, well, we're pretty close. I'm going to set the matter for mediation in January. And the only reason I'm doing that is that most of the mediators are now at this point are pretty full in December. So we will set it for mediation in January. And I'll ask Ms. Brown, is there any attorney mediator that you would recommend in this matter?
I did receive the list of mediators. Unfortunately, of course, this is my first court, I guess, position, but I will have to look through the mediators that were provided.
Okay. Okay. How about you, sir? Is there any that you recommend?
No, sir.
Okay.
I received them, but no.
Okay.
Sure if
What we'll do is we'll just have the mediation clerk, she'll assign a mediator,
Okay.
and then we'll proceed in that manner. So let's see. What we'll do is, again, with the mediation occurring in January, we'll set February 5th at 1:30 p.m. as the settlement conference date. It will be in the order that you're going to get, so you don't have to remember that at this point. And that will be the date that you'll come back to court, and we'll check in and see what's happened as a result of the mediation. Do you have any questions, Ms. Brown?
No, sir. Will we get any additional notification in regards to the mediation, sir?
Yes, the mediation clerk will send you the name of the mediator and contact information, and then being that you're the plaintiff, you're going to have to contact that individual and set up the mediation. And then also check with Mr. Brown to see that he's available, that he can attend the mediation on that particular date as well. Okay?
Sir?
Okay, well, I'll let you go today, and have a good day, and we'll see you back in a few months.
All right. Thank you, sir.
9 a.m.
Thank you.
Thank you. Okay. Good morning to both of you.
Good morning, sir.
This is a scheduling conference whereby the court attempts to put into place various deadlines and processes so the case proceeds in an orderly fashion as we proceed. I'm going to go to the plaintiff first and all the questions because you are the plaintiff. Then I'll follow up with Mr. McIlvaine. Ms. McIlvaine, is there any disputes in the case that you're aware of?
No, not that I'm aware of.
How about you, sir?
No,
Okay.
not that I'm aware of.
Okay. Well, what I'm going to do then, I'm not going to put in place a scheduling order. And the reason I'm not is that kicks into and initiates the mediation process whereby an attorney mediator would proceed with the case to attempt to work with you to get the matter resolved. There's a cost associated with that. So I don't want you to incur the cost if it's not going to be necessary. So what I'll do is give you about 30 to 45 days to see if you can't come to an agreement, get the paperwork done, and then all we'd have to do is wait for the time frame to run before we complete it. Ma'am, because of that you're the plaintiff, you have to prepare the paperwork. That would be a judgment of divorce, a uniform child support order, and a judgment information form. And if you are working with a service such as MichiganLegalHelp.org, they have all the forms on there, and they just ask you some questions. Are you ready to complete the case? Yes. And then it would kick you into preparing the judgment and the uniform child support order and the judgment information form. Do you have any questions, ma'am?
Yeah, I've done that already and turned it in with the rest of the paperwork.
Okay, well, thank you. That's good. When you turn that into the front of the court, we don't get that until later on. So
Okay, gotcha.
that's good that you've been able to get that completed. And what happens is once the front of the court approves it, then get it to Mr. McIlvaine, and then he can approve it. And then all we have to do is wait the time frame for the final hearing, and then we'll be able to conclude it.
Okay,
Do you have any other questions?
I do not. What is the time frame?
180-day waiting period.
Okay,
So we can't complete it in that, but we would be able to have your final hearing before the 180 days, as long as we have the approvals, and then we just wait the 180 days, and then we get it all completed at that
okay.
time. Mr. McIlvaine, is there anything that you have or any questions?
I just have questions on the child support part,
Okay.
like how all that works.
Okay. What happens is the paperwork that Ms. McIlvaine had prepared, she would take her income, your income, she puts it into the formula on the computer, and then it comes out with a number saying this is what the formula recommends as far as support. I don't know if you're on any public assistance or not. Are you receiving any sort of public assistance, ma'am, for the child?
I get nothing, no.
What?
I don't receive anything.
Okay. You don't have any Medicaid or anything of that nature? Okay.
No.
Okay. Notwithstanding that, then that would be the support amount. What's your question as it relates to that, sir?
Okay, that pretty much answers it. I just wanted to verify. I didn't know how all that worked out with it being 50-50 physical and legal custody and whatnot.
That's in the formula. What happens is you put in the incomes, you put in the overnights, and then the formula kicks out a number, and that's what's required to be paid.
Okay.
Okay. If there's nothing else, I'll let you go, and we'll wait, and hopefully we get the approval on that pretty soon, and then we can get the matter completed. I'll probably put it in for about 60 days for a status conference to see where we're at that point. Because quite frankly, I'll tell you, we have hundreds and hundreds of cases, and if we didn't put it in for a status, we'd lose track of it. So, okay.
Okay.
That's all we need to do today. You're free to go. Have a good day.
Thank you, you too.